Okay, so we'll get started and others will join. Thank you all for joining me this morning. My name is Emily Calmeyer. I'm with Hackler Flynn and Associates. I'm looking forward to spending the next hour with you, and I hope that you can take away some of the new laws that we've seen enacted and that are now currently applicable to you as employers. We'll review some of the things that have happened recently. I'm going to give you a little preview of things that I'm seeing with a lot of our clients. And then, of course, we'll have time at the end, hopefully, for questions. But today's presentation is really about making sure that you are compliant with the new employment laws. So just some quick housekeeping per usual. We have a little disclaimer here. We're not giving legal advice. This doesn't create an attorney-client relationship. And as I'm sure you're all aware, often in employment law, it is so fact specific. So we're going to give you some highlights. There may be additional laws that apply to you, but we're really trying to just get you to think of some of the major things that were enacted for 2026 and things that you can do now to make sure you're in compliance. A little about me. I am essentially served for my clients as an outsourced general counsel. So I do everything from litigation to advising on employment issues. I handle some business and contract disputes, government, corporate formalities. So I have a lot of broad ranging experience and of course are helping my clients every day navigate their complicated employee issues. And I think everyone on this call is probably well aware that it's not easy to be an employer in California. So I'm going to start with a very quick recap so we're all on the same page. And again, feel free to put questions in the Q&A and we can revisit them at the end. I am very, informal in my presentations in terms of if you'd like to ask a question or speak, just go ahead and raise your hand on the button and I can allow you that ability. The good news is in the past few years, we've seen a lot of new laws that were very, very heavy on making employers do things, develop workplace violence prevention plans, do a lot of extra training. And so there was a lot to do for employers. This year, there's a couple things you are going to need to do, but it's not nearly as cumbersome as even last year. So there is a little reprieve. On the other hand, as you'll see, there's some new ways for your employees to sue you. So that's delightful. So we saw in the last couple of years, we've seen bans on non-compete clauses in employee agreements. We've seen real focus on developing policies, workplace violence prevention plans. We've seen PAGA reforms, and we're going to continue to see some of those trends in these laws. I will tell you, as someone who is dealing in employment litigation on a day-to-day basis, we are seeing so many wage and hour lawsuits right now, and they continue to be one of the main things we see employees bring, whether while they're employed or after they're employed. So you really want to make sure that you're compliant in your wage and hour to wage and hour law, because as you know, unlike some other areas of law, employment law, there's a lot of opportunity for plaintiffs to recover attorney's fees, and it makes these already expensive lawsuits or demands incredibly expensive. And as you'll hear during this presentation, strong written policies are going to be really important for you, and not just having your strong employment, your handbooks, your written policies, but really making sure you're adhering to those. Quick questions already. Is there any change to the workplace harassment training requirements? No, we're not going to, you still need to do your annual training. Make sure that you have a workplace prevention plan. If your 5+ employees, have your harassment training, but no significant changes there. Great. Okay, so let's just make sure, I'm working with clients every day who wish they had taken a little time, spent a little money to be compliant, to save them the trouble on the back end. the lawsuits that we're seeing a lot of are failure to pay overtime, failure to track hours, failure to pay minimum wage, failure to provide your mandated meal and rest periods, pay stub violations. We're seeing a lot of misclassification lawsuits. So I'm going to talk you through some of that. And again, accurate timekeeping, regular auditing, making sure that your employees are actually following the policies that you've implemented are very, very important. I'm also seeing just as a quick recap, I'm seeing a lot of clients use Chat GPT and AI, which of course we're all, lawyers included, sort of incorporating and using these days a lot more. Some of the tools are better than others. And what we're seeing though, and we'll go over this a little bit more, are employers using those tools to make their employment decisions or to create their policies, and there being a lot of inaccuracies in that, and that leading to liability. So if you're getting, we really recommend against just solely getting your advice or doing your policies via Chat GPT, using it as a tool, but making sure that you are really having someone review that. I had a client who was a small business, didn't have a lot of budget for, a handbook and letters when he was hiring his employees, and he used Chat GPT for everything, and had to pay a lot of money, 6 figures, when he wasn't, it turns out he really wasn't following the law. So again, use it as a tool, but the employment law in California is very, very ticky-tacky and has to be, very precisely followed. So let's just start with some of our, brief overviews. I think most people are aware, but we have our first reminder. Every year, the state's general minimum wage goes up. It's $6.90 an hour. And, most of you with hourly employees are aware of this raise. This is not a particularly complicated issue. But what we do see is people forget that when the minimum wage increases, your salary threshold, if you're classifying an employee as exempt, also needs to increase. So if you have exempt employees, you want to make sure that they're meeting the new minimum exempt salary threshold, which is here on the screen. We have, unfortunately, a lot of clients. We had a restaurant client recently come to us and said, one of his management level employees was accusing him of misclassification, and he had essentially been paying this employee a salary, but he was not increasing that salary threshold to keep up with the increases in minimum wages. So employers tend to sometimes forget that the minimum wage increase affects the minimum salary that you have to pay an employee who is exempt in order for the employee to retain the exemption. So for most exempt employees, in addition to meeting a job duty test, you need to make sure that you're meeting the exempt salary threshold, which, again, you're making sure that your exempt employees are earning a minimum monthly salary of at least 2 times the state minimum wage for full-time employment. Simply paying an employee, just as a quick reminder, simply paying an employee a salary does not make them exempt, and it doesn't change any requirements for compliance. I had a client recently who told me her employee was exempt, so the company doesn't track her hours or her overtime. And then she mentioned her employee makes $50,000 a year in salary. That's a problem, and it's going to buy you a very, very expensive lawsuit. So again, take a look now at it's a great time just to take a look at salaries, to take a look at your exempt employees. And then we'll go from there. I do have a couple questions, some there are questions on the training that I mentioned. So you need to annually be training your people on your workplace violence prevention, and then the sexual harassment prevention is every 2 years. Sorry if that was unclear. We also have just a clarification from Hillary that yes, your exempt employees are not just meeting the salary threshold, they have to meet one of the job duties tests. So common exemptions are administrative, management, things like that. And I hope that answers your questions. Okay. And then if there are some specific industries, so if you're in fast food, if you're in healthcare, there's very specific wage increases. The other thing that I want to remind everyone is that in California, some cities and counties have enacted local ordinances that allow an additional increase, and you need to be adhering to those local increases if you have employees working in those cities. A lot of the 2026 wage increases for local minimum wage are actually in Northern California cities. So if you're in Southern California, for example, we have West Hollywood. And again, for these cities, the employer has to follow the stricter standards, so the one that's more beneficial to the employee and therefore has to pay the higher minimum wage. I think it's a good reminder right now, given all of the remote work, that if you have employees in a city or a specific county, you have to generally follow the employment law of where the employee is doing the work, right? So it's a really good time, just as an action item in January, to confirm that if you do have remote employees, you know exactly where they're doing their work so that you don't find yourself accidentally in a situation where you weren't following employment laws that are applicable. I have a number of clients who, over the past few years, have sort of let some employees work remotely according to specific needs, and that's, certainly fine. But the employers haven't been clear about where exactly are you doing the work? What are the terms of this remote work? Is it temporary? I had one client who thought he was sort of just granting someone temporary remote work due to a family situation. The employee thought, I can work remote forever and travel around the country as I do that. And it obviously caused some problems. So if you do have remote workers, in addition to really knowing where they're doing the work, making sure you're following any minimum wage issues, I highly recommend that you have a very basic remote work policy in your employee handbook or to hand to your workers, so that everyone's on the same page. Again, in employment law, we really want to make sure that everyone is on the same page, because when there's confusion, it tends to lead to lawsuits. Quick reminder, these were some last year, 2025 increases that we saw. And there are some very specific industries, hotel workers, things like that. This is an upcoming February 1st deadline. I'm hoping that this is not news to anyone, but if it is news to anyone, that's fine. You have time. You have a couple days, and it's not, you can do it. I believe in you. So as of February 1st, we have a new requirement that needs to be adhered to. So you may have heard about the new Know Your Rights notice law that is essentially going to end up being a new way for employees to sue you if you do not provide the required notices and annual information. And, as a reminder, plaintiffs' lawyers, the lawyers that typically represent employees, are very savvy, and they know, they're not just going to bring one claim. They're going to throw everything in that they can find where you weren't in compliance. So this is something that we really want to be aware and make sure you're doing. And we're also seeing a lot of disgruntled employees. So under this law, you are essentially providing employees with more information about their rights. So you really need to make sure that you're respecting those rights, that you are adhering to the law so that you don't get sued. We used to say, in California, hey, maybe put your employment posters in the hallway where employees are walking every day, not in the lunchroom where they can sit and stare and think about ways to sue you. So again, this notice that you're going to be providing is going to give employees a lot of information about their rights. So the real fast approaching deadline that you need to make sure you're complying with is the Workplace Know Your Rights notice that has to be sent to employees by February 1st. So the state enacted this law and it's aimed at providing workers with a better understanding of both their constitutional and workplace rights. Under this new labor code section, you as the employer, have to provide employees with the standalone notice of rights both upon hire and annually. So for your existing employees, you're doing it by February 1st and then annually thereafter. And then for your new hires, you're providing this notice when they get hired. So by February 1st, you're going to send this out. The labor commissioner has a template in both English and Spanish, and I'll put the links in to the chat so that you can do that. You can certainly develop your own notice that recovers the required information, but I do highly recommend using the labor commissioner's template. Right now, again, they're in English and Spanish, and they're working on developing other languages. So if you have employees that need it in other languages, for now, you just provide the English notice. The notice is containing descriptions of workers' rights in the right to workers' compensation benefits like disability pay, medical care for work-related injuries, the workers' comp division contact information. It's going to include the right to notice of inspection by immigration agencies, information about protection against unfair immigration-related practices, the right to organize a union, constitutional rights when interacting with law enforcement at the workplace. So your Fourth Amendment constitutional right to be free from unreasonable searches and seizures, your Fifth Amendment right to, under the Constitution, to due process and against self-incrimination. And it's also, these notices are going to be updated annually because they also have to contain new sort of summaries of some of the important new legal developments that apply to employee rights. And then they also contain a list of all the agencies that employees can contact if their rights are being violated. So I want you to provide this notice to employees in the language that you as the employer would typically use with your employees, and that should be a language that your employees understand. I want you to provide the notice as a standalone written document in a manner that you typically use. So for a lot of people, it's going to be email to communicate employment-related information. So email, occasionally text message, or in person. It has to be reasonably anticipated that the employee will receive it within 1 day of you sending it. And again, you need to keep records. This is another area where we need you to keep records of compliance so that if it's ever challenged as to did you provide this notice or you're ever sued and this is tacked on, you have records to show the date that you sent the notice each time you sent it to employees and a copy. And you're going to need to keep those records of compliance for 3 years. The other deadline here that you can see is in March, and you essentially need to provide your existing employees with the opportunity to name emergency contacts and to indicate whether their emergency contacts should be notified if they're arrested or detained on their work site or during work hours or performance of their job if they're not on the work site, if you, the employer, have actual knowledge. And again, for new hires after March 30th, you just provide this opportunity at the time of hire. So this is a little bit in response to some of the immigration things that are going on. So if an employee is detained at the work site, arrested, essentially the state is trying to create a mechanism for you as the employer to notify an emergency contact. And if an employee has asked you to notify their designated emergency contact in one of these situations, you need to do that, right? So if it's on the work site, you need to do it, or if you have actual notice when they're away from the work site but doing their responsibilities, you need to make that notification. This is what the templates look like, the first page. So this just gives you an example of what it looks like. I just want to emphasize again that there are going to be some penalties and there's going to be more enforcement mechanisms. So again, this is another place where we're going to see some litigation if you're not adhering to this requirement. It always gets costly. So please make sure you take the time to send these notices out, incorporate them into your HR onboarding process. I want to just really highlight this anti-retaliation protection because we're seeing a lot of employees claiming retaliation right now. And, unsurprisingly, if an employee exercises a legal right that they have, you as the employer can't retaliate, even if you're offended, even if you're angry, even if you're frustrated. And while I think people tend, generally employers understand that, you really need to think, could this action, which is not retaliatory from my perspective, be seen as retaliatory, be viewed as retaliatory? We see these claims all the time. We don't represent employees, but we get a call at least once a week saying, I reported something, I complained, I had an issue, and my employer changed my hours or put me in a different position or gave me a worse office, retaliated, and I want to sue. We have had cases where employers are so shocked that their most loyal employee sued them. We have had best man suing the groom at the wedding. We have had the siblings suing each other. We have a lot of cases where your 25 plus year employee is suing you. So again, I want you, to the extent you're in the habit of thinking, oh, this person is loyal, oh, this person would never do that, to get out of the habit of assuming that an employee is not going to sue you. I'm going to pause for a sec and see any questions. And so, yes, sending the PDF notice is fine. Yes, if you can, if you want to do the signed acknowledgement of receipt for the rights notice, that's fine. It's not required, but it's always a good, if that is doable for you, if that's not too cumbersome, that's always, best practices. If you have if that can be cumbersome, I don't want a cumbersome requirement to prevent you from actually complying, right? So if it's going to be too cumbersome and take you too long, get those notices out by email. And then I can share the PowerPoint, yes. Sarah, you have a very specific question, so I'll try to come back to you at the end. Okay, so that's coming up. A few other things. Let's talk briefly about new wage reporting laws. So currently the law requires employers, to provide pay scale information in certain circumstances. For example, if you have an employee who essentially is applying for a new job within your company, or someone from outside the company is applying for a job, upon reasonable request of that job applicant, you have to provide a pay scale about how much do we pay for this job? And employers with 15 or more employees have to provide that information in job postings. So before this year, the law defined pay scale as the salary or hourly wage range that the employer reasonably expects to pay for the position. Now, under the pre-2026 law, employers would typically give a salary range or a pay range, which in a lot of cases was really broad, right? And you've probably seen it in job listings, like we expect to pay between 40,000 and 120,000 or something like that. This new law is essentially trying to narrow the scope of your range and remove some of the ambiguity that might exist and give employees a more realistic estimate of the pay they can expect in a job position. So the practical effect is that to the extent you do have to provide a salary or pay range, you're going to want it to be narrower and a more realistic, accurate statement of the pay range you expect to pay. So action item here for you, review any salary ranges that you provide to ensure they're really good faith estimate. Don't make these ranges so broad that you can't argue if you need to, that it was a good faith estimate of what you expected to pay. Okay. A really quick couple of things, and this is going to be with respect to potentially your employee handbooks, and then I'm going to just a few reminders. So we're seeing some updates this year to California's equal pay law. So existing pay law, equal pay law prohibits an employer from paying its employees at wage rates less than the rates paid to employees of the opposite sex or another race or ethnicity for substantially similar work, except under specified circumstances. So under the revised law this year, the verbiage for the equal pay has changed. And the state has decided to broaden the definition of gender. So the Equal Pay Act, the provisions implementing the Equal Pay Act now say an employer shall not pay any of its employees at wage rates less than the rates paid to employees of another sex, right? And so basically, we're aligning the definition of sex with the definition in the Fair Employment and Housing Act, and essentially broadening the definition to include the non-binary genders and reflect a more inclusive workplace. So one thing I'd like you to do is, if you have in your handbook a section on equal pay, I'd like you just make sure the language is correct and that it says, paid to employees of another sex instead of opposite sex. There's also This new law is also making the definition of wages for just this purposes very broad. So this action item for you is to look at what you're paying people and do a little bit of an audit, because now wages includes all forms of compensation, whether it's your straight hourly or salary and overtime, or your profit sharing, your benefits, your insurance, your PTO, that sort of thing, your reimbursements. So you really want to take a broad view of the types of compensation you're offering employees and evaluate and make sure you're not under that broad view of compensation, you're not paying employees of a certain sex or ethnicity or race significantly more for the same type of work. As an aside, this is slightly unrelated, but I've seen a lot of clients recently forget to include certain alternative forms of compensation in the calculation of their overtime rates. So just as a reminder, overtime is based on an employee's regular rate of pay, which is the compensation the employee normally earns for the work performed. And the regular rate of pay includes a number of different kinds of remuneration: hourly earnings, salary, piecework earnings, commissions. So for example, if you're paying your employees a non-discretionary bonus, you do likely need to include that bonus in your overtime calculations. Just a little reminder. Back to the new equal pay provisions. The new law is also expanding the amount of time that employees have to bring an equal pay claim where the cause of action arises out of a willful violation. So essentially, this allows employees more time to sue you. Let me check. Kiana, yes, you can send the Know Your Rights notices electronically, which I agree. If that's the way you typically communicate with your employees, you can send them by email. It really is supposed to be sent in the method that you typically use to communicate employee-related information to employees. If you have a workforce that doesn't use email and you hand them physical paperwork when you need to tell them about something, then do it with your physical paperwork. And in that case, you do probably want, it's more important to have a record, maybe have them sign an acknowledgement. If you have a workforce that communicates via email and you typically send out your employee-related information via email, you can send it by that. Just to go back on the workplace Know Your Rights. Okay, a really quick note on legal changes for some of our larger employers that are on this call. This year, we've enacted a new law in California that has stricter pay data reporting requirements for large companies. So if you have 100 or more employees in the United States, and this pay data reporting requirements are to guard against discrimination based on race, gender, ethnicity. So currently, large employers have to submit pay data every year in May to the California Civil Rights Department, or the CRD, and employers have to submit the number of employees by sex, ethnicity, race in about 10 categories, in addition to things like employee earnings, mean and median hourly pay rates. So, for example, current categories that you have to submit pay data on are executive managers, mid-level sales workers, administrative support records. Starting next year, so I'm just going to highlight it that it's coming into effect soon. Next year, the law is expanding the list of job categories that you have to report on. And they've changed some of the mandatory penalties. So I'm not going to spend a lot of time on this because this doesn't apply to our smaller and mid-sized companies. But again, You're just going to want to make sure that you're prepared, that you're preparing this year to be able to report next year on expanded categories. I'm going to take a quick look at the questions. Okay, so Rashawn, when does the pay scale on job descriptions go into effect? So that's in effect now. So you need to be, if you have an applicant who inquires, or if you have that if you meet that 15 plus employee mark and you're doing job postings, you need to include the pay scale. Okay. Patty, let's come back to you. And 100 plus means in the US? Yeah. Yes, correct. All right. For those of you in a business where employees get tips, so restaurants, hospitality, things like that, the state is very concerned that those tips are not getting to the employees and that there are fees or delays that are being applied to the tips. So again, this is really to protect employees in getting their tips. If you're, for example, have a restaurant business and your employees get tips via credit card, that full tip amount has to go to the employee without any deductions for credit card processing fees or any other, those type of deductions. You need to treat tips in the same, if for some reason you capture tips and through credit cards, they're not getting their tips right away, they have to be paid no later than the next regular pay date. And you need to maintain detailed records. So really it's prohibiting employers and their agents from taking, collecting, withholding gratuities. This new law is also going to grant the California Labor Commissioner new enforcement powers to come after you. So if an employee complains that they're not getting their tips, the Labor Commissioner is going to be able to investigate it, allegations of tip theft, issue citations for violation, and even file civil actions to recover. And so I just want you to be very careful if you have tips that your employees receive, that you have policies in place that ensure you are not violating this law and that your employees are getting the tips. And so that's very important. That's a really great thing too to include in your handbook. If you have a tip-based business, in your employee handbook, having a section about employee gratuities that essentially echoes, we don't take them, we don't deduct for credit card fees, that kind of thing is very important. We work with a lot of restaurants, and this continues to be an issue for restaurant employers. It can be hard to keep track of things, and so you just really need those clear policies. I don't want you to accidentally, most things that my clients do are not on purpose. Most of us are trying, most of my employers are trying to adhere to California law, and it's just so difficult. It's so complicated. It's so confusing. So I don't want you to be accidentally collecting gratuities or making some deductions or paying gratuities late. Okay, personnel records, just a quick note here. There's been a little expansion of the law about the types of personnel records you need to maintain. Just first as a reminder, there are strict laws about keeping personnel records, what to keep, what information needs to be kept, what has to be separate. Generally, personnel records have to be kept for 4 years, but I recommend to be ultra safe keeping them longer, 6, 7 years. And if you think that's cumbersome, just remember that workers' comp records have to be kept for up to 30 years, which I find farcical. So existing law provides your employees the right to inspect and review personnel records that the employer does maintain relating to their performance or employee-related grievances. Under this expansion, if you are in the practice of maintaining education and training records, which a lot of you are because you're maintaining records about, your harassment training, or your workplace violence prevention training, or just any training or education that's specific to your business. So if you are maintaining records, now those records have to be provided to employees if they request it. And if you're maintaining those records, you actually have to provide the information on the screen and make sure that those records contain the employee name, the training provider, what, when and where the training happened, what the training covered. And also, if you get like a certificate, if your employees get a certificate, you have to keep a record of that. So again, this is again just sort of record keeping cleanup, and it's a good thing to look at your record keeping practices in general right now. Failure to adhere to this is penalties. It's another claim in a lawsuit. And so it can really have consequences that you don't want to deal with. Really quickly, next up, we have new provisions to the FEHA, to the Fair Employment and Housing Act, implemented to encourage employers to conduct bias mitigation training. And essentially, this law is meant to affirm that, if you conduct bias mitigation training, it does not by itself, constitute unlawful discrimination. So essentially, if people are admitting to their own biases, they're not admitting to, being discriminatory. Again, I like to encourage you that in addition to any bias mitigation training you do, most of you need to be doing annual workplace safety training and sexual harassment prevention for those of you with 5 or more every 2 years. It's a good time to just check your recent training schedules, make sure you're in compliance. I see a lot of questions. The workplace violence training is for all employees, and then the supervisors have specific requirements, but you need to be doing that annually. Okay. All right. So this essentially created just basically a safe harbor. A lot of employees and employers were concerned that if they offered bias mitigation training, it would be used against them later. Really quickly, another new law is that we have relates to have employee contracts that are in restraint of trade. So it's attempting to prevent employers from requiring their employees to pay back money at the end of their employment. So there's a few exceptions, but generally now the Business and Professions Code and the Labor Code prohibit employers from requiring employees to repay certain debts at the end of the employment relationship. So anytime you have an agreement or a policy where you are asking an employee to pay something back, I want it to be a little red flag that you say, is this legal? Can I do this? And check in with your lawyer. So basically, the state does not want employees to incur a lot of debt to their employers, which is then due back at employment and might sort of discourage employees from moving employment. They don't want, it's a free market system, and we don't want things that might discourage employees from moving. So unless there's a specific exception or exemption, which there are, employers cannot in a contract or as a condition of employment now require that workers pay back a debt or authorize debt collection, and you can't impose a penalty or fee on the worker if the employment ends. The law has specific definitions of debt. So debt is money, personal property, or their equivalent that is due or owing or alleged to be due or owing. So it could be employment related costs, education related costs, consumer financial products or services, regardless of whether the debt is certain, contingent, or incurred voluntarily. I'm going to review on this next slide a few general exemptions. And so again, I'm not going to review all the details of these, but there are certain exempted categories where certain contracts would be allowed. I think that places that, and the two that are probably going to be most common are contracts related to the repayment of tuition costs and contracts where you can essentially, in certain circumstances, claw back, compensation like unearned bonuses. I would like to just caution you that these exceptions have specific requirements. So if you want to fall under one of these exceptions, you have to meet the very specific requirements of that exception. So it's not just that any contract related to tuition can, falls outside this new law. So you really need to make sure that you're in that meeting the specific legal requirements. I also would like to take this time to remind you that if you have commission plans or non-discretionary bonus plans, they need to be in writing. If you haven't reviewed them in a while, give us a call, talk to your lawyer, your legal department, have those plans, whether they're plans that apply to a group of employees or a specific executive. Make sure that they're clear, that they're in writing, that they say, how are things earned, when are they paid, in what circumstances are they advanced or clawed back, because we see a lot of problems with that, where there's sort of oral promises made or the plans themselves are very vague or not in writing. Okay. Questions? Are cash advances made by employees included as debt? Not necessarily, but it's going to be very detail specific in terms of like, what are you advancing? Unfortunately, in employment law, a lot of it is like very particularized. Okay, so again, this is what happens. One thing to note is this rule is prospective. It's not retroactive. So it only applies to contracts that are executed after January 1st of this year, 2026. It is going to be another area where an employee can sue you if you are in violation of this law. And as you can see on the screen, there are real significant consequences. We work with a lot of clients who are larger and that if they want to do mass layoffs, have to really be cognizant of our Cal Warn Act. So, for example, we work with a manufacturing company that produces health foods, and they've significantly reduced their workforce over the last, year or so, going from like 250 employees to 80 employees. And, excuse me, they've done a lot of this through layoffs, and we had to work really closely with them to make sure that they were compliant with the WARN Act. So again, I want to, if you are subject to the WARN Act and you're going to be doing layoffs, I want you to know that starting this year, there's new things that you have to do and coordinate under the WARN Act, and new notice information that you have to provide. The key here is if you're going to be subject to the WARN Act due to layoffs, restructuring, things like that, you really need to plan it out in advance. Like when we worked with our manufacturing client, we really worked in advance of the layoffs to make sure all of the I's were dotted and T's were crossed. And I want to tell you, this is really true in employment law in general. I have a lot of clients who are employers who call me at 5 p.m. and say, I want to fire someone tomorrow. There's an issue, it's gotten too much, whatever. And they want to fire the person at 9 a.m. the next morning, and they say, help me. And I really suggest, reach out, but know that often it's better to slow things down, to plan in advance, than to just terminate and find that you haven't provided the correct information, or you haven't taken all the procedural steps. More often than not, in employment law, emergencies aren't true emergencies, and employers get themselves into trouble for acting too quickly. So as a reminder, the Cal Warn Act applies to employers with 75 plus employees and requires 60-day notice for mass layoffs where 50 plus employees are affected, for plant closures, relocations, etc. And essentially, this act is meant to give employees advance notice for their job loss. And you'll see here on the screen, there's 4 new areas of information that need to be included. I have a question. Is it prudent not to give employees loans, not for tuition, but for financial assistance? Yeah, you do not, for the most part, want to be giving your employees loans for money. I would just say that's a general rule to operate. Like they're in a bad financial situation, it's going to cause you problems down the line. Less than 75, but the whole staff of 5 is laying off. So you wouldn't fall under the Cal Warn Act, but I still think there's things you can do communication wise to sort of walk your employees through, help them make sure, releases, have them sign releases, things like that, so that they don't turn around and sue you, which is what we're trying to avoid. Quick note, there were a few minor changes to jury and witness duty leave. So now employees can use their vacation, their PTO, their paid sick law for these leaves. So I'd like you to go into your handbooks and update that accordingly in your leave sections. Additionally, the law used to require employees to give reasonable advance notice for jury leave, full stop. Now they don't have to give that notice if it's not feasible. Would I argue that you probably do know in advance that you have jury duty leave? Yes. But again, just know that go into your handbooks, make sure that that the verbiage, allows them to use their compensatory time off, and jury duty leave requires reasonable advance notice unless the advance notice is not feasible. I want to make sure that that language is in your handbook. The state keeps expanding the ability for employees to take leave related to being, crimes, victims, court proceedings. So if an employee comes to you and says, I need to take leave because I was a victim, my family member is a victim, I'm being called to testify, I need to go to a sentencing hearing, a plea hearing, any of that kind of thing, I want you to, make sure you're not saying, no, that's not allowed. I really want you to check to make sure that that leave request falls under one of the legally mandated leaves, because it likely does, given how much we've expanded this area. Now employees again can use their accrued time off, their paid sick leave, to attend judicial proceedings. And this new leave, starting this year, it provides protected leave for employees who are victims or family members of victims to attend judicial proceedings related to those crimes. So again, it's kind of in the last couple of years, all these victims leaves and witness leaves and judicial leaves have started to sort of fold in on each other. But this judicial proceedings leave is different from witness leave. So we have leave for jury duty, witness duty, victims judicial proceedings leave, victims of qualifying acts of violence leave, and then for employers with 25 plus employees, just a reminder of existing law that in addition to giving people leave who are victims of qualifying acts of violence, there's a whole expanded list of outside services leave related to that qualifying act of violence that employees can take time for. So you want to make sure your handbooks are up to date. Let me take a quick look. Patty, I will circle back with you on that specific question. If our policy already covered 5 days paid, then are we okay under this law? For Hillary, I need a little more information, but if you're saying, for example, our policy already says you can go take time off for judicial proceedings and it's paid, then you are likely compliant. But the timing might be something you want to look at. Okay. And there's different, times available for each of these leaves. Really quickly, I just want you to know that if you owe a wage judgment, the state's going to start coming down harder on you. We've enacted a new law in the state that says for employers who have unpaid wage judgments are going to face significant penalties, very large penalties, if the unpaid wages aren't paid within 180 days after the time to appeal expires. So I just want you to be aware of that. It probably doesn't apply right now to most people, but I do want you to know that the state's cracking down on employers who have unpaid wage judgments. Very briefly, because we're approaching the end of our time, we get a lot of FEHA violation claims. And so basically, failure to provide reasonable accommodations, engage in the interactive process. And so there's been some changes structurally and procedurally in some of these in the law this year that's going to allow a little more room for and time for employees to bring these claims. Moving right along, there's a few new independent contractor categories, and I highly doubt anyone they're applicable to anyone on this call. I don't imagine we have any commercial fishers on the call. I want to just use this slide though as a reminder because I am seeing it weekly in demand letters. California continues to strongly disfavor the use of independent contractors, people who are being paid by 1099. Sometimes people call them consultants, 1099 workers, independent contractors. I think everyone on this call should be aware of this, but I'm going to say it again because I'm seeing so many lawsuits. There are very, very specific legal tests and rules as to when and whether an individual worker can be paid as a 1099 independent contractor versus employees. These tests vary by industry, by business, by role. If you have any 1099 independent contractors, I want to make sure that you did not set that up as some sort of default or because the worker said, it's fine, this is how I always get paid, or this is how we've always done it. You need to make sure you're properly classifying people because it's going to be very expensive if you make a mistake. You're going to face fines, lawsuits, a lot of liability, a lot of attorney's fees. So again, I want you to be able to articulate, if you use 1099 contractors, why under the specific legal test they are allowed to be 1099 contractors. Because in California, the state presumes that everyone is a W-2 employee. And if you want to have a 1099 contractor, independent contractor, you have to prove and argue out of the W-2 bucket and into the independent contractor 1099 bucket. It's not which could they be, it weighs one way or another. It's you have to remove yourself from the presumption of a W-2. And if you don't know now why someone is legally allowed to be a 1099 contractor, I want that to be a priority for you so that you are not sued and so that you don't face a lot of liability. Because, a misclassification claim, whether it's between non-exempt or exempt or independent contractor W-2 employee, employees never just bring that claim. They are tacking everything they can onto those claims. And they're going to be looking for ways that you didn't conform to the law. I want to highlight some new rules that went into effect in these last minute or two, and then I think we'll have a couple questions. I'm happy to stay after for a few minutes to answer questions. If you're using automated decision systems, essentially AI, or if your vendors are using AI to hire, promote, evaluate, there are new rules that have been issued to make sure that your processes are not discriminatory. And then remember, garbage in, garbage out. So you need to make sure that you're following these new rules and that you're not using these systems, even if you don't mean to use them in this way, in a way that creates discrimination based on a protected category or class. So as an action item, I want you to talk to your vendors. I want you to talk to anyone you work with. I want to look at you, to look at your systems, and I want you to do some bias testing, some screening, assessing how these systems work and what the outcomes are so you do not run afoul of these new rules. A couple just really quick miscellaneous things. I'm going to highlight that there has been a COVID right to rehire extension. So for those of you who had restaurant or hospitality workers, there's been an extension of your obligation to notify former workers of new open positions according to seniority. Again, I don't think a lot of these are going to apply to the majority of people, but again, remember, we're seeing a lot of wage and hour lawsuits right now relating to missed meal and rest breaks. So make sure, please, that you have a good policy, but that you're enforcing the policy. If your employees are not taking their meal and rest breaks, or they're cutting corners on times, that's going to come back to haunt you. You need to enforce them. There needs to be disciplinary action. If you let people get away with it, it may feel good. If you let, or, if someone says, oh, I don't really want to take my breaks, that you might be like, well, that's what they want, but that's going to come back to haunt you. Um, we have just a couple minutes, so I want to highlight a couple things we're seeing in the case law, because remember in California, we have statutes as new law, and then we have case law that also is creating new law. So if you get hit with a minimum wage or misclassification claim and you want to make a good faith defense argument, you have to show evidence that you actually have tried to comply with the law, not just sort of a general, we try. Real, like, paper trails of compliance efforts, documented policies, legal consultations, things you've done that are documented that you can present. If you are not going to be able to defend yourself saying, well, we orally told everyone and we thought it was fine. I'd also like to, for those of you who have arbitration agreements with your employees, the courts are invalidating these left and right, and a lot of it is based on how it is presented to the employees. So if you are presenting, when you're hiring someone, if you're presenting an arbitration agreement to the employee, you print it out. Please do not send it electronically for them to sign. Make sure it's 12 points, single-sided. Do not give it to someone in a stack of papers. Set it aside, give them time to read it. It should be in the language that they use, English, Spanish, whatever that language is, so that, for example, like some of the case law we're seeing that's up on the screen, you're not having your arbitration agreements invalidated by the court. And similarly, we really want to make sure you have policies and practices in place to take harassment complaints, hostile work environment complaints seriously. I will skip through these. We're looking forward, just two things. The courts are really focusing on trying to send more cases to mediation. So we're going to see some changes in the law around mediation. And then this is looking forward a couple of years. Our paid family leave is going to have an expansion starting in 2028. So it's something to kind of think about now. So we're going to have an expansion of employees able to access paid family leave to take time off to care for a designated person with a serious illness. Okay, so that's our quick hour. I could talk for hours and hours on employment law. Again, as you can see, it's not quite as heavy in terms of things that employers need to do, but this is a great time to make sure that you're in compliance, because we are seeing a lot of employment lawsuits right now. Okay, I'm going to just look through. You've been asked many occasions if employees can use their sick time for vacations. You've said no, but is that correct? So sick time in your handbooks, you should have listed all of the things that people can use sick time for. It's prescribed by statute. And typically you just want to be very careful about denying or even inquiring into sick leave. So, typically if you want to just take your own vacation, that's not something that you would typically be able to use paid sick leave for. But also you want to make sure that what they're actually asking for, maybe it isn't actually a vacation. Make sure that what they're asking for you understand correctly and the way you're responding is correct. Can company get sued? Not if they excuse the company. I'm not sure, my anonymous attendee, what that means. So if you want to reach out, please do. The hybrid, again, I'm sorry, I'm not going to be able to get to all of the questions. So I'm just going to kind of pick some of the big ones, and I'm happy to circle back to those of you individually. It seems LA is moving to hybrid positions. That your company is moving to hybrid positions for employees. Yes. So if you have employees that are working 3 days remotely and 2 days in the office or whatever that is, you need to have, I really highly recommend that you have a remote work policy. We have very basic, we do a lot of very basic ones for our clients. They're page, 2 pages at the most, bullet points. It's, you're telling people we're allowing you to work remotely, but it's not, we can revoke that in our sole discretion. We expect you to have this in the following workspaces. We expect you to still be doing your work, things like that. So we want to make sure the expectations are set so that if you have to discipline someone, you can point and say, hey, you agreed to this policy. All right. That was quick. I hope this was helpful. If anyone has any other questions, please let me know. If you want, I'm going to stay on a few more minutes. For those of you who want to, feel free to raise your hand and I can actually, you can have the opportunity to speak and I can answer questions. But please let me know if you have anything else, and I hope you all have a great day. Okay, I'm just gonna try to, a few of you, looks like maybe you want to chat, so I'm gonna just, you have your hands up. Okay, Patty, you should be able to speak, and Hannah, maybe it looks like you had a question.
I did. Thank you for all the information. It was so helpful. I just wanted to confirm that the Know Your Rights notice, the flyer handout that was created by the state of California, I guess for the labor commissioner, would that suffice, or you
Yes.
suggest that we create a um, different version of the form?
No, I would suggest that you use the one that the labor commissioner, the template. Let me go back to that slide and put in the chat. I have the links for those of you who want it. No, I would suggest that you use those templates. We might see over time companies starting to use their own templates, or even the litigation develop where it's clear that for some reason these aren't really the best templates. But right now, um, the labor commissioner was tasked to develop a template specifically for employers. So go ahead and use that. All right,
Sure.
let me
Yeah.
put this in the Q&A. I think, let's see, what's the best way to do this? Um, can you all see all of the Q&A questions, Hannah?
No, I
Okay,
can't.
I'm going to do it. I'll put it in a chat. Okay, so here are the links. Hopefully those came through, the English and Spanish version.
Perfect. Thank you.
All right. Pet Pals HR. Did you have a question?
Can you hear me?
Yes.
So, we actually interview a job candidate last year who applied for our job, but then she was not qualified. And then this year we post the similar job again, and then she said that we did not hire her because of discrimination.
Okay, and is she just, this is a very specific thing. So has she actually sent you a demand letter or is suing you? Is that sort of just a general claim? Where are you in the process?
No, she just leave her message on Indeed.
Okay, so why don't you go ahead and reach out to me? I can't give you a specific advice on that
Mm-hmm.
on such a specific issue.
Okay.
But why don't you reach out to us? And if you want specific legal advice on how to handle this, we're happy to provide that.
I'll email you.
Great. And my email is just my name, Emily, EMILY, at hacklerflynnlaw.com.
Okay, thank you.
Okay. Patty, did you have a question?
Yes, I was wondering, I've gotten my employee handbook done for about 4 years with Hackler Flynn, and for the last year or so, I haven't. Is there any way of, or who should I contact to get that employee manual updated?
Oh, great. We can definitely help you with that. Orchid or I can help you, and we can get that done. And we find that if you're updating them annually, they don't take a lot of work. It's our clients who don't update them for a few years where there's a lot that's changed. So, Patty, if we have a copy, we can do that. If you want to just shoot me and Orchid an email saying, here's my current, and I'd like to get it updated. Orchid does this day in and day out, so she can give you a few quick updates.
Okay, perfect. Thank you.
Thanks, Patty.
Also, one last question. I have an employee who's an excellent employee. For some reason, he can't get a driver's license and he doesn't have a credit card. Um, he has asked us to, before his shift, to purchase Uber for him. So we've done this for about a year now, and we take it out of his next check. Is this something I should be doing? I'm afraid it looks like that we're taking every week $200 to $300 out of his check.
Yeah, that could definitely. So he's saying he cannot himself um, hire Uber because he doesn't have a credit card to put on the account. That's the setup,
Correct.
and he can't get to work unless he takes Uber.
Correct.
Yeah, I think let's talk offline. I think absolutely this could be problematic for you. Not that you can't offer a benefit like this to a client, or excuse me, to an employee, but you really can't. There's really specific things you can deduct for. So this is definitely one of those things where you sort of, I could easily see this person coming back and saying, they said they would pay voluntarily for my Uber, and now all of a sudden they were improperly deducting my paycheck every week, a very large amount. So I think we need to look exactly at if there's ways to do this in a very organized, documented way, and look at how that then gets paid for specifically. But that's a pretty specific thing.
Okay, thank you.
Yeah, I would go ahead and I know that you work with Orchid a lot, so I would just go ahead and or I'll just give her a heads up that that's something you guys need to address.
Okay, thank you.
Yeah. Anything else? Any other questions?
Well, I do have one about paychecks.
Okay.
Starting with the first week in January payroll, they changed the way that they paid people overtime. They would take in account mileage, they'd take in account anything else that we paid them for, sick time, and they created this weighted overtime. And a lot of times it ended up being less than the time and a half. So
Yeah, that's going to be problematic for you.
I had
So
them stop it.
yeah, that's right. Overtime, and again, Patty, don't share necessarily a lot of specifics on this call, just for your own, attorney-client confidentiality. But and we can talk offline. But the law, so many lawsuits right now relating to overtime, and the laws are so strict. The rules are so strict about how you calculate overtime, what is included. And I find that a lot of my clients use payroll companies, and the payroll companies don't always know the exact bounds of the law. So I'm not saying in this particular circumstance it's an absolute no go, but what I'm saying is we need to look at exactly what's happening and then what the effect is to make sure you're in compliance. Same with, I have like a lot of employees using, employers using like Gusto and other paycheck or payroll companies. And you really need to make sure, for example, that that you are listing on pay stubs the required information. In California, we have very specific requirements on what has to be on a pay stub. and it's specific information. And when we get these wage and hour lawsuits, which again I'm getting weekly, often failure to adhere to the requirements in California of accurate pay stubs is a claim in there, and it just increases the liability, and then it increases the plaintiff's attorney ability to recover fees.
Okay, thank you.
Yeah. All right. Okay, everyone. Unless there's anyone else, I really encourage you to take time, I know it's hard when you're running a business because you have so much coming at you, and you're just, a lot of my clients are just scrambling to stay open. But take some time each week to make sure the administrative items, the compliance items are being looked at so you can find your problems now. So I have so many clients that had they spent a couple hours just fixing a few things, spent a little money up front, they would have avoided paying 200,000 in a settlement or 100,000. But really, unlike a lot of areas of law, our employment lawsuits get expensive quickly. So I encourage you to do some auditing, to look at your handbooks, to look at your policies. I hope everyone has a really great week, and please feel free to reach out with any further questions.
Thank you.